morning and welcome back to the third lecture in the series. This lecture I have intentionally numbered as 2A. The last lecture you saw, we learned about Article 335 and Article 341 and 42. 341 and 42 is primarily about the powers of the President to notify scheduled caste, scheduled tribe. And we also saw that a scheduled caste, scheduled tribe in a particular state shall be deemed to be scheduled caste, scheduled tribe for that particular state only, and it has a tremendous implication, and we discussed that we will talk about it in the next video, which is this one. We'll see that when scheduled caste, scheduled tribe migrates, either because of jobs seeking employment opportunities, or girls marrying and going to other state to stay with their husbands who are working there, it has got its implication that scheduled caste, scheduled tribe benefits that they were getting in their original state will not be entitled in the new state or the state to which they have migrated. So this is we will learn in detail today, and there, although Article 341 says that he shall be deemed to be scheduled caste or scheduled tribe in respect of that state or union territory, as the case may be, this has got an impact on his rights of reservation. So the question has been coming up before the Supreme Court from time to time, and the issue which was that whether is there any conflict between the Article 16 and also the rights of the person to freely move around in the country versus his denial of right of reservation, which necessarily flows from the last three lines of Article 341, which we had learned. I have given a name to this video, which let us call it to migrate or not is the question, because very briefly, as I have told you, when a scheduled caste, scheduled tribe or an OBC candidate migrates from his home state to any other state, he is not entitled to the benefit of reservation in the state government jobs and the state government run educational institutions. And therefore, there is this question that how do we scheduled caste or a scheduled tribe candidate benefits when he migrates. So the fact still remains that he is a scheduled caste, he is scheduled tribe, he will be entitled to all the benefits of reservation for central government jobs and central government educational institutions. But when it comes to state government jobs or state government educational institutions, he will not be entitled to the benefits. Now, as I was telling you, this issue has been time to time reaching the Supreme Court, and the first major judgment of a constitution bench was in the case of Chandra Shekhar Rao versus Dean Seth GS Medical College and others, and this is a judgment of the year 1990. The facts itself are very interesting, and this petitioner, as you can see, Chandra Shekhar Rao is the appellant. So when he went to the Supreme Court, obviously that means he had suffered some disadvantage. The disadvantage that he had suffered was, although Chandra Shekhar Rao and his father were basically from Andhra Pradesh, Tenali, but they had come to stay in Bombay for a long time. His father got a job, and when he grew up and applied for MBBS admission, Chandra Shekhar Rao originally belonged to Tenali. So this is the map of India. This is where Andhra Pradesh is, Tenali, and his father got a job in Mumbai, Rashtriya Chemicals and Fertilizer Limited, which is a Government of India undertaking. So they traveled and settled down from Tenali to Mumbai, and Chandra Shekhar Rao completed his class 10th, 12th, all in Mumbai. Chandra Shekhar Rao judgment is a constitution bench judgment. As I told you, is a 5-judge constitution bench judgment, and this is a case where Chandra Shekhar Rao belonged to a scheduled tribe called Godu, Goudu, in the state of Andhra Pradesh. Originally, as I told you, he belongs to Tenali. He was born in 1969. So he completed his education in Mumbai because his father got a job there. He grew up. He applied for his MBBS admission in the year 1989. After completing his class 10th and class 12th from Mumbai, he applied for four colleges. Three run by Bombay Municipal Corporation, one by the state of Maharashtra. Now, these are not central government education institutions, state government educational institutions. And there were scheduled tribe candidates lesser marks than him who got admitted, but he was denied admission because he was not treated as scheduled tribe by the colleges. So his claim as scheduled tribe was denied, although he had produced domicile certificate also. Of course, he was staying in Maharashtra for a long time, more than 10 years. Now, when the matter went to the Supreme Court, and Supreme Court interpreted Article 341, according to which a scheduled tribe or a scheduled caste will be scheduled caste, scheduled tribe in respect of that state only. And this was restricting the claims of the SC/ST on migration. On the one hand, if you interpret 341, on the other hand, there was this Article 16 by which reservation could be provided in government jobs, and Article 15 by which reservation was being provided in educational institutions. So there was a conflict, but the Supreme Court interpreted the Constitution by the well laid down policy of doctrine of harmonious constructions. Therefore, Supreme Court upheld the decision of the college and held that the petitioner cannot get the benefit of reservation as scheduled tribe, applying this important doctrine of harmonious construction. Harmonious construction basically is nothing but a doctrine by which whenever you interpret a statute or the constitution, if there is a conflict between two provisions of the statute and the constitution, then they should be so interpreted that none of them become meaningless or nugatory as called in legal terms. So there is no surplus in the constitution. This is the basic presumption. Everything in the constitution has a meaning. Now, if Chandra Shekhar Rao, who was a scheduled tribe of Andhra Pradesh, is also treated as a scheduled tribe of Maharashtra, then remember those last three lines will become nugatory. What were the last three lines of Article 341? That he shall be deemed to be scheduled caste, scheduled tribe for the purposes of this constitution in respect of that state or union territory. Although Chandra Shekhar Rao case very clearly settled the issue, these questions kept on cropping before the courts, and again in the case of Action Committee on issue of caste certificate to scheduled caste, scheduled tribes in the state of Maharashtra versus Union of India. Now see, the Union of India was the respondent. The case is 1994. Again, it is a 5-judge bench. The issue came up, and the question framed by the court. Please see the question. This is important because in the Chandra Shekhar Rao case, the Gaudu community of Andhra Pradesh was a scheduled tribe in Andhra Pradesh, but what not listed in the as Gaudu was not listed as scheduled tribe in the case of Maharashtra. But now in the case of Action Committee case in 1994, the question framed by the court was very interesting. The question is whether a person belonging to caste A in the state X on migration to state B, where also caste A is recognized as SC/ST, will he be treated as scheduled caste, scheduled tribe or not? This was the question framed. And you know very well that whenever things goes to the court, they first frame the issues, frame the questions on which answers are to be. That is why the judgments are so very interesting to read and so very important to be read word by word and understood. Now, in this case, the judgment was again following the Chandra Shekhar Rao ratio, and Government of India's orders of 1977 and then 1982 were also considered. And finally, the court held that on migration, a person will not be treated as scheduled caste, scheduled tribe to the state he has migrated. Of course, he will be scheduled caste scheduled tribe to his home state. And the Government of India's Office Memorandum 1982 was also considered. Department of Personnel Trainings had issued an instructions in 1982 that interestingly, in this case, the Union of India never filed its reply, although the court observed somewhere in the judgment that unfortunately, even though the main challenge is to the communication circulars issued by the Government of India, but no counter has been filed by the Government of India. But this is interesting, facts associated with this. The next important event has happened in 2005. So 1990 is Mari Chandra Shekhar Rao, 1995, 1994 is the 1994 is the Supreme Court judgment and the Action Committee. So almost 11 years later, this judgment of S. Pushpa and others versus Sivachand Mugavelu and others. This is a case of Pondicherry recruitment. So government of Pondicherry is recruiting candidates, and the question is whether scheduled caste, scheduled tribes of other states, union territories will be considered as scheduled caste, scheduled tribe for the union territory jobs of the government of Pondicherry as scheduled caste, scheduled tribe or not. Now this is a 3-judge bench. In this case, as I told you, it's a recruitment of Pondicherry, and the Supreme Court 3-judge bench held that the SC/ST candidates from the other parts of India would also be considered as scheduled caste, scheduled tribe for recruitment to Pondicherry government. Now you can see that without going into too much of the legal interpretation, you can almost clearly see that this is contrary to the judgment of Mari Chandra Shekhar Rao and Action Committee. So obviously, S. Pushpa again created a confusion because the well-settled law of Mari Chandra Shekhar Rao and Action Committee was disturbed, and of course, this is applicable only for Union Territory of Pondicherry. So, S. Pushpa judgment, the Honorable Supreme Court 3-judge bench interpreted the various provisions by which Union Territory is governed through the center and came to the conclusion that Union Territory's position is slightly legally different from the cases of states. So states and Union Territory cannot be compared in the same manner, and therefore distinguished the Mari Chandra Shekhar Rao judgment and Action Committee, which were applicable to states. So they said in Union Territory of Pondicherry, scheduled caste, scheduled tribe of other states, Union Territory will also be considered. However, in 2009, Delhi, so in Subhash Chandra and another versus Delhi subordinate service election, so you can of subordinate service election, and the 2-judge bench, when it went to the Supreme Court, the 2-judge bench of the Supreme Court declared that the view expressed by the 3-judge bench in S. Pushpa was per incuriam, as it was in violation of the binding precedent of Mari Chandra Shekhar Rao. Now, but it basically means that any judgment given by the Supreme Court in violation of a binding precedent is a wrong judgment, is a wrong law. In 2010, in the state of Uttaranchal versus Sandeep Kumar Singh, the 2-judge bench again of the Supreme Court did not approve the approach adopted by another 2-judge bench in Subhash Chandra case. So the Supreme Court, now when this Uttaranchal case came to Supreme Court, of course in this case Sandeep Kumar Singh was not a SC/ST of Uttaranchal, but he was trying to claim reservation in Uttaranchal, although he did not belong to Uttaranchal. So again this question came whether he is entitled to reservation or not, and while perusing the previous judgment, the 2-judge bench of the Supreme Court said that a 2-judge bench could not have, 2-judge bench of the Subhash Chandra could not have held it per incuriam of a 3-judge bench judgment, and they should have referred the matter to the larger bench. So they themselves referred the matter to the Chief Justice for setting up a larger bench to decide this question once and for all. You have seen the confusion has arisen because of S. Pushpa, which has held that in Pondicherry, scheduled caste, scheduled tribe, other states are entitled. So this. Now we are talking of a very, very interesting case, and the facts are so very interesting that the interpretation of the law will have now more meaning to you. The case is Ranjana Kumari versus State of Uttaranchal. The year is 2013. Now Ranjana Kumari is a girl from Punjab belonging to Valmiki caste, which is a scheduled caste in Punjab. Now she marries a person of a Valmiki caste, but who is not from Punjab. He is from Dehradun, Uttaranchal. Now, as we have just discussed, that in case of marriage, it has no change on the caste tribe either of the husband or the wife. Sometimes people get confused that the wife has added the surname of the husband. It has got no effect on the tribe or the caste of the wife. Before marriage, after marriage, it remains the same. So obviously, after marriage, the girl remains scheduled caste, the boy remains scheduled caste. There is absolutely no change in their caste status. But when Ranjana Kumari settles down in Uttaranchal and applies for a job in the state government of Uttaranchal, district information officer, for the post of district information officer, she is denied the benefit of reservation as scheduled caste. Kindly see, very interesting now. Valmiki caste is a scheduled caste in Punjab. Valmiki caste is a scheduled caste in Uttaranchal also. Yet she is denied the benefit of it. You have already seen that both in Chandra Shekhar Rao and Action Committee case 1994, the Supreme Court has held that even if the caste is listed as scheduled caste or scheduled tribe, to the state you have migrated, you will not be getting the benefit of it. So matter went to the Supreme Court again. And on 23rd September 2013, the Supreme Court first referred the matter and framed the question first. And the question is very interesting. Please see, the courts have this unique culture of first framing the issues, framing the question. The question arising in this appeal, in para 15 the court has held, the question arising in this appeal is whether a person like the appellant, that is Ranjana Kumari, who is a scheduled caste in the state where she was born, that is Punjab, will not be entitled to the benefit of reservation after marriage in the state where her husband is living, despite the fact that the husband also belongs to scheduled caste and the particular caste, in this case Valmiki, falls in the same reserved category in the state of migration, and that she is a permanent resident in that state. Now this girl Ranjana Kumari has come to permanently stay in Dehradun, and even then whether she will be denied or not. The Supreme Court again in the Ranjana Kumari suggested, this two-judge bench suggested that this case should be referred to a larger bench. And now in the year 2018, in the case of Bir Singh versus Delhi Jal Board, this question finally came to be, I hope finally has come to be settled. In this case, again a 5-judge bench referred and framed the question like this: whether a person belonging to scheduled caste in relation to a particular state would be entitled or not to the benefits of concessions allowed to scheduled caste candidates in the matter of employment in any other state. In this 4:1, by a majority of 4:1, the Supreme Court held that for all states, scheduled caste, scheduled tribe of only those states would be considered as scheduled caste and scheduled tribe. So by a majority of 4:1, one judge, Justice Bhanumati, dissented. 4:1 judgment also held, the majority view also held, that for all the states this is true, that only the scheduled caste, scheduled tribe of that state would be entitled to the benefit of reservation, but they made an exception, and that exception was Delhi. So in Delhi they say treat scheduled caste, scheduled tribe of all states as scheduled caste, scheduled tribe because of the peculiar legal position of the Delhi. I am not going into the legal arguments put forth by various parties because this is not a lecture on law. This is basically a lecture on handling reservation issues in the government of India and government of state. So the Supreme Court finally settled the question which was haunting of those who are handling reservation policies, is that scheduled caste, scheduled tribe of only the states to where they belong, there only they will get the benefit of reservation. When they migrate, they will not get the benefit of reservation. Exception is Delhi. Justice Bhanumati deferred. She said even for Delhi, people from outside should not be entitled to benefit in view of the judgment of the Mari Chandra Shekhar Rao. But as we know that a majority judgment prevails, and therefore by the majority judgment, things are now settled, and except for Delhi, a scheduled caste, scheduled tribe of any state will not get the benefit of reservation when they go to other states. He will be entitled to benefit of reservation for the purpose of Delhi government jobs. So this was the short story of migration, and the law you have understood. Hope you have liked my video. Please subscribe if you have liked it. Please freely feel to give me any comments on feedback on the YouTube channel. Thank you very much. See you next time.